All rise, veuillez vous lever. Please be seated. Veuillez vous asseoir.
Before we continue, Ms. Dimitri, you have additions to your team, perhaps for the record. I think it's good to have everyone who is present really reflected in the transcript.
Thank you, Mr. President. Indeed, we have our 3 interns, Romane Corret, Evelise Ndakusan, and Amaury Mandose.
Thank you very much. I give now the floor to Mr. Seprun for his final arguments.
Merci, Monsieur le Président.
Thank you, Your Honour. Your Honour, Your Honours, the trial which ends today has given rise to 3 feelings, or if you like, 3 perceptions in the minds of the victims that I represent, 292 of them, and who are former child soldiers of the anti-Balaka group under the command of Mr. Rombo Yekatom. The first is the feeling of confidence, since, according to the victims, it has been established on the basis of numerous pieces of evidence produced during this trial that Mr. Yekatom must be found guilty, beyond all reasonable doubt, for the commission of the crime to which the victims were subjected. In particular, the crime of conscripting and enlisting children under the age of 15 into his anti-Balaka group and using them to participate actively in hostilities. The second is a feeling of concern about the length of the trial, which victims consider to be excessive. The third is a feeling of frustration, because the victims feel that they have not been able to fully realise their right to contribute effectively to the search for and establishment of the truth in this case, and also because many of their expectations of this trial have not materialized. I echo the views and concerns of the victims I represent, and so, in my speech, I'm going to touch on 3 themes. Firstly, the extent of the victimization of the child soldiers of Mr. Yekatom's anti-Balaka group. Secondly, the extent of victim participation in this trial. And thirdly, the views, concerns, and frustrations of the victims in relation to this trial. With respect to the first issue, in my final written submissions, to the extent possible, and within the page limit as accorded to the legal representatives of victims, I have demonstrated, with reference to the evidence produced during the trial, such as witness testimony and video and documentary evidence, that children under the age of 15 were conscripted, enlisted, and used to participate actively in hostilities by the anti-Balaka group of Mr. Yekatom. I reiterate in full by reference to all my final written submissions, in order to demonstrate the extent of their victimization of anti-Balaka child soldiers, I will summarize their experience in the group, without, however, citing sources, as they are included in my written submissions, but also because we are in open session. It has therefore been established during this trial that children under the age of 15 were conscripted, i.e. forcibly recruited, into the anti-Balaka group when they were in their respective villages, or on the road between their villages and their schools, or on fishing grounds, or in the forests. Other children joined the group, supposedly voluntarily, guided by different reasons. Some wanted to take revenge for the murder of members of their family by the Seleka. Others, because they were led to believe by friends or family members that once they were in the group, they could easily earn money. Others, because they were looking for protection or support from adults. Still others, because they did not go to school and they had no other occupation. Finally, there were those who believed that their experience in the ranks of the anti-Balaka could enable them later to join the Central African Armed Forces. Whatever their motivation, the mere fact that Mr. Yekatom's anti-Balaka group recruited into its ranks children under the age of 15 constitutes a crime under the Rome Statute, since the consent of a child is not a valid excuse. Furthermore, these children must no doubt have very quickly regretted joining the anti-Balaka ranks, as the reality that awaited them once they were in the group was shocking. Once in the group, the children were subjected to various forms of physical and mental violence, and this regardless of whether the child had been forcibly recruited or was supposed to have joined voluntarily. This was because once in the group, the child could no longer leave it at will, since in that case, he could have been considered by the leaders as a group traitor, and by way of consequence, if caught running away, could have been punished or even killed. Following their recruitment, children were typically taken to one of the anti-Balaka bases, where they were first required to undergo a traditional initiation procedure, the procedure known as blindage or armor plating or vaccination, since, as we saw during the trial, the anti-Balaka elements apparently believed in the strength of the fetishes that would be able to protect them against the enemy. Regardless of whether the strength of the fetishes worked as hoped, the traditional initiation of children, as testified to by the expert on child soldiers, could constitute a form of indoctrination and instrumentalization of the children in such a way as to make them feel as if from now on they had to belong to the group without being able to leave it, but also to make them even more manageable and more controllable, since this initiation imposed rules on the children that had to be respected imperatively, failing which the protection of the fetishes would cease to function. From their first day in the group, the leaders gave the children narcotics to take, such as Indian cannabis or tramadol, to help them overcome their fear and shyness, and to make them strong and courageous. In fact, according to the expert on child soldiers, administrating drugs to child soldiers turned them into veritable killing machines, transforming them into fearless and merciless fighters. Administering drugs to children also served another purpose, in particular to get rid of their hunger, because there was a lack of food in the group, and the children were systematically malnourished because of the regular use of drugs within the group, anti-Balaka group. Several children developed an addiction to the extent that they continued to take them long after their demobilization. After their traditional initiation, some children underwent military-style training, while others had to pass a test, which involved the children proving to their leaders that they were ready to fight against the enemy. To this end, the children were forced either to kill or to mutilate one of the prisoners, or simply to observe the killing or mutilation of a prisoner. The children played different roles within Mr. Yekatom's anti-Balaka group, in particular as bodyguards for their leaders, spies, and ammunition carriers. They were deployed on patrols, at roadblocks, and to protect bases. They were ordered to fetch food, and as part of this, they had to loot civilians' property. And in order to do so, they often had to attack civilians to take away their belongings. They were also ordered to finish off wounded prisoners. During their experience in the group, the child soldiers were subjected to another form of indoctrination, in the form of speeches by their leaders about the need to defend the country and drive out the Muslims. They were also subjected to various forms of punishment and other forms of ill treatment. The girls, apart from household tasks, were subjected to sexual violence by the chiefs and other elements. In addition, the girls were involved in traditional practices with the aim of mystically preparing for combat and protecting in the same way the anti-Balaka elements. Finally, the child soldiers have been used to actively participate in several battles, among others the attack on Bangui of the 5th of December 2013 and in the battle in Boda. Your Honour, Your Honours, the experience of the child soldiers in Mr. Yekatom's anti-Balaka group has caused various forms of both short-term and long-term harm. In terms of immediate harm, the recruitment of children into the anti-Balaka group immediately led to their separation from their families and the interruption or stopping of their schooling. Once in the group, the children, who were already vulnerable, given their age, were exposed to an environment of violence and fear, continuous violence and fear, which undoubtedly harmed their physical integrity and caused immediate psychological trauma. During their experience in the group, the children were subjected to various forms of physical and mental violence, which undoubtedly only increased their vulnerability. Using children to take active part in hostilities exposed them to the imminent risk of being killed and also led them to commit atrocities under the influence of drugs administered to them. Many children never returned from the battlefield, and those who did still bear the scars of injuries and disabilities and are marked forever by the sound of gunfire and explosions, as well as by images of their comrades killed. Children who were also victims of sexual violence while in the army suffered various types of additional harm, including unwanted pregnancy, infections, sexually transmitted diseases, injuries to the genitals, and in the long term, sexual dysfunction, feelings of shame, humiliation, guilt, and self-hatred.
Monsieur le Président, Madame et Messieurs les juges.
Your Honour, Your Honours. The suffering of the child soldiers in the anti-Blacker group did not end, unfortunately, when they were disarmed and demobilised. This is because the atrocities of war and violence that the children were lucky enough to survive then turned into the ordeals of their daily war to cope with the long-term consequences of their painful experience. Trauma expert in the present case, whose report was admitted into evidence, states that after continuous exposure to violence, fear and anxiety, to inhumane treatment and especially to sexual violence, combined with the systematic use of drugs, former child soldiers generally suffer from psychological trauma that persists long after their demobilization from the army, and it often develops into post-traumatic stress. This trauma has detrimental effects on the development of the brain and cognitive abilities of young individuals, as well as on their behavior. And it often leads, apart from depression, aggression, anxiety, memory problems and suicidal thoughts, to disassociation, developmental problems, and social reintegration. This traumatic experience can also give rise to intergenerational damage, and furthermore can also cause family and community dysfunction. With regard to the specific harm that former child soldiers typically suffer is post-traumatic stress disorder, which, according to the expert on trauma, states occurs in between 97 and 99% of former child soldiers. The expert on child soldiers also testified that after their demobilization, former child soldiers are very often stigmatized and rejected by their families and communities because of their experience, and, as a result, have difficulty reintegrating into society. According to this expert, rehabilitation programs are not always effective for all former child soldiers, as many of them are unable to find their place in civilian life, and they prefer to join armed groups again. I'll now go on to my second theme, which is the extent of victims' participation in this trial. Your Honour, Your Honours, we have all been able, throughout these 22 years of experience or existence of the court, we've all been able to observe on numerous occasions that during their internal interventions and public speeches, the representatives of the different organs and sections of the court like to talk a lot about victims, in particular about how important participation of victims in proceedings before the court is, while stressing that the court cannot properly fulfill its mandate without the effective participation of victims. I'm only going to cite one example, which is more recent, and that is the speech made by the President of the Court to the United Nations General Assembly on the 31st of October 2022. The President of the Court said, and I quote,
"The ICC has ushered in a concept of international criminal justice that gives victims a strong role in the process. That victims have a very strong position at the ICC, and the ICC invests a great deal of time, energy, and resources into making the victim-centered vision of justice a reality." Fin de citation.
End of quote. Furthermore, throughout the various cases, the court has established and reiterated on several occasions the principle according to which participation of victims in the proceedings before the court must be effective and meaningful, and not merely symbolic. I recognize that this is a very fine principle, but it only exists on paper, because the reality is absolutely different. In fact, in reality, the extent of victims' participation in proceedings before this court depends entirely on the composition of the chamber concerned, and this extent varies significantly sometimes in different cases, with the worrying trend in recent years of chambers applying an increasingly restrictive approach to the extent of victims' participation, and in particular to their right to contribute effectively through their legal representative to the search for an establishment of the truth. Throughout this trial, we have regularly heard that the legal representatives of victims should limit their examination of prosecution and defence witnesses to issues relating to the harm suffered only by victims, and should not act as prosecutor bis, since their role in the proceedings is very limited. With due respect, I find it regrettable that 22 years after the creation of the court, we are still debating the role and rights of victims in proceedings before this court. It is therefore important to remember that victims play a distinct and independent role, including in relation to the prosecution. The interests of victims are distinct from the interests of the prosecution and may not be consistent with the interests of the prosecution. In fact, the main interest of victims is to be able to effectively realize their right to truth and justice with its essential components. The right to contribute positively to the search for and establishment of the truth, and the right to be listened to and heard. I therefore must repeat the appeal that I made at the start of this trial, which clearly has not been heard. Victims are not here to play the role of prosecutor bis. The victims are not here to assist the prosecution. But neither are the victims here to play the role of a pure symbol in whose name and for whom the International Criminal Court is dispensing justice. I recall that in one of its written submissions, Mr. Yekatom's defense argued that we are not here in these proceedings to establish the truth with a capital T. As far as I'm concerned, in all my years of experience in assisting and legally representing victims in various cases, I have always been convinced that in addition to determining the criminal responsibility of the accused, the ICC, by virtue of its commitment to victims, also has an obligation to establish the truth with a capital T, insofar as this truth falls within the parameters of the case, or the court in any case must do everything necessary to ensure that this truth is established. In any case, the victims need, and I'm convinced, have the right to, the truth with a capital T. Victims don't need the smallest truth, a half-truth, a partial truth. So they don't need the handicapped truth that only suits certain people. The search for the truth is a long and complex process. It requires the effective contribution of all those who are able to provide relevant evidence, including victims, through their legal representatives. In fact, the prosecution, for strategic or other reasons, may have no interest in exploring certain aspects of the case with the witnesses, even though these aspects directly affect the personal interests of the victims. And this is precisely where the legal representative must be able to contribute, as this is necessary to establish the truth with a capital T. And the personal interests of the victims must in no way be limited to questions of the harm suffered by victims, since personal interests of victims are far from being limited to this issue. I'll give you an example where it concerns the crime of enlisting and conscripting children under the age of 15 into an armed group and using them to participate actively in hostilities. which is one of the crimes for which Mr. Yekatom has been accused. In the interest of this case, the prosecution only needs to show, as a material element of the crime in question, that at least one child under the age of 15 was conscripted or enlisted into Mr. Yekatom's anti-Balaka group, or at least one child under the age of 15 was used to participate actively in hostilities conducted by the anti-Balaka. That is all. The prosecution does not need, and moreover has no obligation, to demonstrate, for example, the different roles played by children in the group, the living conditions of the children within the group, the different forms of treatment, military training, discipline, and punishments to which children were subjected, and so on. It should, therefore, be the role of the legal representative of victims to address these aspects, as they directly concern the personal interests of his clients. Of course, only if we all have the objective of establishing the truth with a capital T rather than a disabled truth. The specificity of these crimes is that any kind of experience of children in the anti-Balaka group necessarily relates in one way or another to the acts or omissions of the accused. The result is that virtually one of two issues that I've tried to raise in this trial with witnesses, beyond questions of harm, has been objected to by the defence, and in most cases the objection has been sustained, with the reminder that the legal representative must not act as prosecutor bis, and that the role of legal representatives in this trial is very limited. If the prosecution for strategic regions has not had the interest to raise such issues, and the legal representative is not authorized to do so, then who will? Logically, no one. The smallest truth being established as a result. I would ask myself, therefore, a rather rhetorical question of whether and to what extent the approach according to which the role of the legal representatives of victims in this trial should be limited is reconcilable with the established legal principle in the jurisprudence of this court that the participation of victims in proceedings before the court must be effective and meaningful and not merely symbolic. This restrictive approach to the extent of victims' participation in the trial has had negative implications not only for victims' rights, but also for legal representatives as counsel. In fact, legal representatives have obligations under the Code of Professional Conduct for counsel before the court, according to which, amongst other things, each counsel must act in the best interests of his or her clients. These obligations apply equally to counsel for the defence and counsel for victims, without distinction. If, in reality, unlike defence counsel, victims' counsel are not systematically authorised, for example, to discuss with witnesses all matters that directly concern the interests of their clients, this means that they are prevented from exercising their mandate in accordance with their obligations under the Code. This leads to the de facto creation of two categories of counsel with different rights and obligations that are not, however, contemplated by the Code of Professional Conduct for Counsel. I cannot fail to mention another example of the restrictive approach to the extent of victims' participation in this trial. This concerns the stage of the trial relating to the presentation of evidence by the legal representatives. In this case, contrary to the consistent practice in all previous cases, the legal representatives were given 1 month and 1 week to file an application for leave to present evidence with the final list of proposed witnesses, including the summaries of anticipated testimony. As a result, the legal representatives were simply deprived of the opportunity to conduct their investigations properly and to prepare adequately for the trial stage, crucial as it is for the victims. I am aware that the trial chambers of this court, like the pre-trial chambers, are not obliged to conform with the practice of the other chambers. However, we are dealing with a single court, and this court is supposed to ensure the consistency and predictability of its own jurisprudence. Predictability is one of the essential requirements of every legal system, whether national or international, such as that provided for in the Rome Statute. Predictability of the Rome Statute legal system is required not only to enable counsel to have a more or less clear idea of what they can expect from a procedural point of view. It is also necessary for the court's reputation or for the image of the court to demonstrate this institution is able to ensure consistency and predictability of its own jurisprudence. Reversal of the court's practice in this matter was justified by the fact that the trial, in this case, had already taken so long. With all due respect, it is as if the legal representatives of the victims had never been, they had asked for a delay in the trial, and the only way to remedy this would have been to dramatically shorten the time taken by the legal representatives at the essential stage for their clients. In addition to the restrictions already imposed on victims' right to effectively contribute to the search for and establishment of the truth. It is true that in this trial we have two defence teams, which could in itself explain the extended duration of these proceedings, which is 3 years and 6 months, 3.5 years. But in this trial, there are also two teams of legal representatives of victims. By way of illustration, although I do not have a precise calculation, it is nevertheless reasonable to say that throughout this trial, the two teams of legal representatives have used a total of no more than 15 hours for their examination of all the witnesses. For 3.5 years. However, each defence team used an average of 5 hours per witness, sometimes even 8, 10, 12 hours per witness, with no restriction on the issues that could be addressed. The question of whether the legal representatives of victims were in fact responsible for the excessive length of this trial is purely rhetorical, as the answer would seem obvious. It has to be said that the extent of victims' participation in this trial has been restricted to the minimum possible. Furthermore, it should be noted that the extent of victims' participation in the trial that is currently taking place in parallel, and which also concerns the situation in the Central African Republic, in particular in the Said case, appears to be even more restricted, a purely symbolic limit. Since, for example, the legal representative only has the right to examine his clients, victims with dual status, and does not have the right to ask any questions of any other witness on any other subject. The trend in the court's practice in recent years, consisting of applying an increasingly restrictive approach to the extent and scope of victims' participation in proceedings before this court, is very worrying, and I would say unfortunate, not only for the victims who participate in the cases concerned, but it is also alarming for the future of the whole system of victims' participation before this court. We all know that the Rome Statute is unique in its kind, because for the first time in the history of international criminal justice, it provides for the right of victims to participate at all stages of the proceedings. The authors of the Rome Statute intended to place victims at the heart of proceedings before the court, while giving the chambers the discretion to establish and develop, through their practice, a precise and fair system that would be consistent with their intentions. This unique system of the Rome Statute required the court to find and implement a fair and equitable balance of proportionality between the different interests, on the one hand, of the rights of the defence, and on the other, of the right of victims to participate in proceedings in an effective and meaningful way, and not merely symbolically. It has to be said that 22 years after the creation of this court, this balance has never been found or put in place. I had the honour of being part of one of the teams of legal representatives of victims who took part in the trial of the very first case before this court, the Lubanga case. In that case, we had before us only the legal text of the court, without any practice of the court or any relevant international jurisprudence. We faced two challenges. Firstly, to find the legal basis for establishing the modalities for victims which were as favourable as possible, which could then be developed in future cases. Secondly, we had to try to convince the chamber, the trial chamber, presided over by the British judge, who came from the common law system, and he was therefore unfamiliar with the concept of victim participation in criminal proceedings. By way of consequence, during the trial in this case, 3 teams of legal representatives of victims were authorized to ask witnesses, in addition to questions related to the harm suffered by victims and possible reparations, any question relating to the criminal responsibility of the accused, the context of the case, the nature of the armed conflict, as well as any question of a general nature. The only condition was that the legal representatives could ask questions on issues that had either not been addressed at all by the prosecution or had only been addressed in part by the prosecution. And contrary to what some may think, the extent of victims' participation in this case, 3 teams of legal representatives, was not the cause of the delay in this trial. I would like to remind you that this trial has had delays because it was suspended twice due to problems with the disclosure of evidence by the prosecution. In addition, the Chamber, in that case, established the principle that the right to present evidence is not limited to the parties, but may extend under certain conditions to the legal representatives of victims. The results of this very first case, the very first case before the court with regards to the extent of victims' participation, has given rise to reasonable optimism that the principles established in this case will be developed further and in favour of victims in future cases. And it's true that the principles established in the Lubanga case were followed in the Katanga case and to a certain extent in the Bemba case. I wonder how we, the court, 15 years later, have managed to get to this point when the role of the legal representatives has been restricted to such an extent that now they can only raise with witnesses questions relating to the harm suffered by victims. It's reasonable to say that, starting with the Bagbo and Blade Goudet cases, the whole system of victims' participation in proceedings before this court, paradoxically, rather than developing favourably for the victims, began to regress, or rather, I would rather say, began its free fall, and I'm afraid that this fall is not yet over. Given the worrying trend in the court's practice regarding the extent of victims' participation in proceedings, including in this case, we have now reached the moment of truth, with a capital T, for the whole system of victims' participation. There are 2 options before the court. Take it or leave it options. Firstly, it is imperative that the court seeks and, if possible, finds at the central institutional level the requisite fair and equitable balance of proportionality that would ensure that victims' participation is effective and meaningful and not merely symbolic, and that the approach adopted is applied uniformly and consistently across all proceedings before the court. Secondly, and if not, the court should consider openly acknowledging that it is not in a position to ensure such a level of victim participation in practice. At least that would be honest. In both cases, this is necessary now, because the system of victim participation in proceedings before the court, in its current state, and with the latest trends, resembles a Titanic approaching its iceberg. In other words, the unique value of the Rome Statute, which is the participation of victims in proceedings before the International Criminal Court, is about to be completely levelled. Your Honour, Your Honours, this brings me to my third and final theme, which is the views, concerns and frustrations of the victims, former child soldiers of the anti-Balaka, in relation to this trial. Firstly, the former child soldier victims regret that the mode of criminal responsibility under Article 28 of the Rome Statute, which is the responsibility of the military commander, was not included by the prosecution in count 29 of the indictment against Mr. Yekatom. In fact, for the victims who were former child soldiers, Mr. Yekatom de facto played the role of their military commander during their experience in the ranks of the anti-Balaka. Therefore, Mr. Yekatom's role as a military commander of the anti-Balaka group should have been properly examined, as it should have been during the trial, and should have been taken into account by the Chamber in its determination of Mr. Yekatom's criminal responsibility. Secondly, the former child soldier victims regret that the prosecution did not include in its document containing the charges an additional charge relating to the crime of sexual violence committed against anti-Balaka child soldiers. In fact, as demonstrated during the trial, girls who were part of the anti-Balaka ranks were subjected to sexual violence during their time with the group. Therefore, sexual violence against child soldiers of the anti-Balaka should have been examined in detail during the trial in order to ensure that all forms of victimization suffered by child soldiers in the anti-Balaka ranks were taken into account by the Chamber in its determination of Mr. Yekatom's criminal responsibility. Thirdly, the former child soldier victims regret that many of their expectations in relation to this trial have not materialized. Despite the fact that their expectations have been expressed before the court on numerous occasions by their legal representative. Indeed, the victims hoped that the trial in this case would draw the attention of international and national humanitarian organizations to their difficult situation as a result of their experience in the ranks of the anti-Balaka, in particular their medical and psychological problems, their problem of stigmatization by their respective communities, and their problem of social reintegration. However, only a certain number of former child soldiers of the anti-Balaka have been able to benefit from assistance, albeit limited, under the Trust Funds for Victims Assistance Programme. However, under this programme, specialised medical treatment was offered only to victims of sexual violence. The other former child soldiers concerned received only basic medical assistance. The former child soldiers received no help or assistance from anyone else. Finally, only a very limited number of former child soldiers were able to follow developments in this trial through radio programs broadcast in their respective villages. For the vast majority of victims, their legal representative was the only source of information on developments in the trial. Victims regret that their repeated appeals to put in place additional means that would allow them to follow the developments in the trial on a regular basis, such as periodic outreach activities in their respective villages or through cine video shops, have not materialized. By way of conclusion, the eyes of the former child soldiers of Mr. Yekatom's anti-Balaka group, who are now young adults, are turned towards the International Criminal Court, towards you, Mr. President, ladies and gentlemen judges. These young adults hope that the outcome of this trial will give them the opportunity to obtain reparations for the suffering and the different forms of harm they have suffered during their experience in the ranks of the anti-Balaka, as well as reparation, as far as possible, for their stolen childhood. Thank you.
This concludes the hearing of today. We continue tomorrow at 9:30 with the presentations by the defense.
All rise, veuillez vous lever.